Judge Sullivan and Judge Smith, thank you for joining us this morning for our interviews. I already gave you a letter outlining AAG and how we're handling the endorsement process this year, just to expedite matters so we can jump right into the actual interview. For the record, Diana is running for re-election in Justice Court 12, and Doug Smith is running for re-election in District Court 8. Being the chivalrous group that we are, we will start with the lady. And Judge Sullivan, why have you decided to run for re-election in this particular department at this time?
Well, when I first ran for election back in 2008, my goal at that time was to serve one term in Justice Court and then to run for District Court this cycle. And I got a little off track. I changed that goal because, I don't know what else to say other than I love this job. I think this job is very important. I think it's more important than some people tend to think. We make very important custody decisions at the beginning of the cases, which sometimes last throughout the life of the case. And so I think sometimes Justice Court isn't given its credit and it's important that it deserves. And I'm taking it very seriously. I want to continue to take it very seriously. I want to continue to improve the administration of Justice Court and the efficiency of Justice Court. And I don't think my life is up in Justice Court at all.
And just to clarify, you had mentioned custody decisions early on in a case. Just for the edification of other people, you're not referring to family law or domestic law type custody. It's not child custody, it's physical custody, as in whether a person's on house arrest or in jail.
Correct. To detain them or to release them from custody in jail pending the process.
Correct. Just in case for anyone who's watching this online, once we post the videos, I don't want them to think that you handle family court matters. Same thing with Judge Smith. Neither one of you two.
Yeah, that's a good point. Thanks for clarifying.
So, and Judge Smith.
I have been a judge for 22 years. My entire practice in the legal arena has been in Las Vegas. My family, my wife is from Las Vegas, born and raised here. Her father was born and raised here. And of course my children have been born and raised here in the public school system. I believe that I am there to protect society and to manage my courtroom, and I believe that I still have much work to do. I enjoy the district court. I enjoy hearing criminal cases and civil cases. I hear both, and I just believe I still have more to give the public.
Okay. Doug, in the 22 years that you've been on the bench, obviously you've seen a lot of changes. What changes still need to be made from an efficiency standpoint regarding district court? And I'll have the same question for you, Judge Sullivan, for justice court.
I think that trials need to be more efficient. I believe that we pick juries, and sometimes when we finish that jury trial, the next day we pick another jury. And I just think that our trials can be more efficient and we can get our decisions done. I try to be to work early. I'm usually in the summer at work by 5:30 in the morning. I'm at work during the school year so that I can help my wife get the kids up. I'm at work by 6 or 6:15 every morning so that I can get my cases prepared, ready for trial, and decisions completed. I have no decisions on my desk that have not been completed.
Okay. Judge Sullivan.
Well, I do prepare my calendars every day, the day before, so when I take the bench, I know about that case that I'm calling, or in some circumstances there's 100 cases on calendar in the morning, but I already know what that case is on calendar for. So I don't need the clerk to tell me what the case is on calendar for, or the lawyers to tell me what the case is on calendar for. I know exactly what it's on calendar for. And I think every judge should be that prepared, because when a judge is not prepared and has to seek guidance from everybody else in the courtroom, that's when you get delayed. Secondly, I tend to think sometimes we could spread out our calendars. For anybody that's been in justice court, we do a lot of work in the morning at 7:30 or 8 o'clock, and there are a lot of cases on calendar, sometimes, like I say, 100 cases in an hour and a half, and then we start a new calendar at 9:30. that gets backed up. We're waiting on lawyers, we're waiting on witnesses, we're waiting sometimes on defendants. And sometimes I think it can be more efficient if you spread certain calendars out throughout the day. The problem is, when I've looked into that and asked around about that, there are all different fingers or tentacles of that octopus, if you will, that is almost impossible to make that happen. You have to deal with the district attorney's office, you have to deal with the public defender's office, you have to deal with a law enforcement that carry all different types of shifts. So to try to spread your calendar out throughout the day, even though it sounds like it would be more efficient because you're handling less cases on, let's say, each calendar setting or each docket, it prevents lawyers from doing their job in other ways, such as going to visit their clients in the jail or prepping for their calendar the next day if they're a district attorney. So right now, Justice Court is bogged down in the morning, and the only way to get through the voluminous docket is to be prepared.
And I've been in front of both of you. Oh, I didn't say this. I don't have any active case in front of Judge Smith, to my knowledge. I haven't been in there representing anyone for a long time, although I did testify about a year ago in front of you, and that was a pleasure. Judge Sullivan, I may have a few status check type cases, but I don't think I've had anything substantive in front of you for a long time. When these situations arise, obviously I'll handle the moderation of the endorsement interviews, but if I'm in front of someone on too regular of a basis, I feel there's potentially a conflict there, so I don't participate in the deliberation process. I don't see that as a problem, definitely for Judge Smith, and I don't think so for Judge Sullivan, because I'm very rarely in there.
Right.
Maybe once a month, if that. So, just for the edification of others. Judge Sullivan, you had mentioned, the mornings are very packed, but the afternoons tend to be a little more open. And I know I've appeared in front of both of you in the past, and I know you've scheduled hearings to be heard in the afternoons to use that time more efficiently. But when you don't have those hearings, are there any other projects such as diversionary court programs or youth programs that you're trying to establish or that you want to establish or continue working on should you be reelected?
Well, I have a diversionary program right now, which is a GED program. Basically, we try to, if it's a kind of a first-time offender that hasn't had a lot of contact with the justice system and it's a misdemeanor offense, we try to divert them into getting their GED or their high school diploma. If they're willing, we don't force that on them because I think we don't want to set them up for failure. So they have to be willing, but we do give them a diversionary program to get their case dismissed at the end. And sometimes I'll go around and maybe that person has 3 cases open in the system, but they're new cases. I'll go around and collect those other 2 cases from the other judges if I can, to hopefully for that defendant to benefit at the end for all 3 cases being dismissed if they get their GED. But I also, I handle things in the afternoon, such as I'm the chair of the Civil Rules Committee. We are in constant process of revising our civil rules in Justice Court, our local rules of practice, and that is an ongoing process. It's a very laborious process. Once you get something revised, sometimes it takes a year and a half to get rules revised, and then once rules are revised after a year and a half, now it's time for the next revision. So it's kind of a continuous process. But I'm the chair of that committee. I'm also on the board of the NJLJ, which is our Nevada Judges of Limited Jurisdiction. So I do have some roles as board member there. I'm right now going through the bench book and making sure there aren't any glaring inaccuracies of the bench book that go out to all the limited jurisdiction judges in the state. So there are things to do in the afternoon, even though some people tend to believe there are not. You can find things to do. You just have to want to find things to do to help improve the system in the court.
Okay. Judge Smith.
Well, in the mornings, we handle law and motion calendar. We start at 8 o'clock. I try to be done by 9 so that we can start our trials. Trials, the biggest complaint I've heard from attorneys is the judges don't give them a full day of trial. And a full day for me is between 9, 9:30 and 5 o'clock in the afternoon. My breaks have a tendency, if I take an hour break, have a tendency to be less than an hour. I'm back on the bench usually within 50 minutes. I don't believe that we should take long breaks, and I try to give the attorneys time because I'm a trial department, and so we try cases, both civil and criminal, and you have to give them a full day. It's not fair to the public, it's not fair to the defendants, and it's certainly not fair to the attorneys.
Do you see the need to expand? I realize you are in trial a great deal, but to expand into any diversionary programs, I realize you haven't handled mental health court. It's been assigned to other judges or other programs like that. Do you have any ideas as to how district court can more fully support some areas of need for individuals like mental health court or veterans courts or things of that nature?
Trying to get to understand those courts and sending individuals that you believe when it comes up to sentencing. We have less of an opportunity to work with people as they do in justice court. As you know, I served 16 years as a justice of the peace, and so I know that you can work with people. And when we get up to district court for trials, you're dealing with the attorneys, you're dealing with experts that you have to be prepared to put on for trial. So we have less opportunity for diversion. But if we don't have a trial, if our trial resolves, then we can go to overflow trial, grab a trial and try cases. I think I was the first or the second for the last 3 years in picking up overflow trials. Also, we have mediation so that we can bring in civil cases and mediate them. Now, I would like to see mediation in criminal cases as well. I know that the Supreme Court doesn't want the judge that's trying the case to get too involved, but I think that if a defendant could sit down and talk to a judge in a different department that has, no horse in that race, but can tell them that their feelings about the case and the attorneys, for both parties have to have their attorneys present, of course, and discuss the case, that perhaps we could resolve it and do more trials that are unresolvable. It's a proposal that I've talked about. It hasn't caught on real well.
What would have been the biggest hurdles? I mean, the opponents of that, what are their criticisms?
The opponents say that judges shouldn't get involved in negotiating cases. When I started in 1982, the judges would tell us to negotiate the cases, and they would get actively involved. And sometimes the attorneys don't know their cases. And we see so much experience in trials that you try to help folks, and that gets me in trouble. Even if both parties ask you to help, that gets you in trouble.
If I can just respond to something that
Please.
Judge Smith said. In justice court, I agree that I am a believer that the trial judge should not be the one that's participating in trying to resolve the case. But I think it is very important to try to utilize your brethren and your colleagues to get involved in trying to resolve cases. For example, Judge Cruz, Cynthia Cruz, who's handling an all-civil docket right now, about 3 weeks ago came to me and said, Diana, I have a trial coming up, and I would really like to have these parties have a settlement conference. She said, I don't want to be the settlement judge because I'm the trial judge. Would you be willing to hold the settlement conference for these parties? Because I know nothing about the case. And I will handle your criminal docket that morning. And I said, absolutely. That when I was doing civil docket, Judge Zaragoza and I would kind of switch off. I would try to handle settlement cases for her and vice versa. But Judge Cruz, when she came to me about 3 weeks ago, was the first time that she kind of crossed the civil criminal lines, which I think is great. Because I have a full civil background before I took the bench. So she said, and she came up with, there wasn't, we wouldn't have to utilize a pro tem for that. We could start it in the morning, and she could handle my criminal docket. I didn't get to do the settlement conference because apparently they settled the case before it even went to settlement conference. But that is a great idea that I think we can even utilize in justice court, because settlement conferences are important in justice court and the civil cases as well as in district court.
And see, in district court, we have a judge that is assigned the management of our settlement conferences. And so your civil cases go to him if you think that it's deserving of a settlement, or at least a look at for settlement. And then the other civil judges that have had their trials negotiated, very often what happens is maybe the Monday morning when you go to get ready for trial, it's resolved. Then you have that week, you can't call witnesses in and say, hey, we're open this week. So that's why you have overflow. I can start a case on Wednesday, or I can do settlement conferences. Sometimes you do 2 or 3 a week.
And just to inform other people, what's overflow?
Overflow is if you have, sometimes you'll have 6 or 8 trials set. The cases that don't have out-of-state witnesses or that won't be lengthy or not difficult issues will go to overflow. And that means that you can't try it. Maybe another judge who has their calendar opened up can take that trial. So that you're not sitting and doing nothing for the public.
Yeah. And so that the people are getting their day in court
Yes.
when it's regularly scheduled, for lack of a better term. And Mindy, did you want to jump in? Because I know you have some knowledge of the inner workings of justice court as
I
well.
do, and I love both of them. I do have one question. What, for both of you, is what standard of review would you use on an issue of first impression that has not been addressed by any district in the valley?
You want me to start?
Yeah.
In trials, the standard of review is what is fair to the public. You have, as a district court judge, you really have 2 charges: manage your courtroom and protect the public. And if you can look at the issue and determine what is best for the public, then you make that call.
Well, obviously, we don't have a standard of review as an appellate court because we are a limited jurisdiction court, but at looking legally at an issue of first impression, whether it's interpreting a statute, you really need to give it the common sense and plain language of the statute. It's interesting how we can have a 2-hour argument about one word in the statute. And sometimes everybody's argument is reasonable. It's just how we're going to interpret that one word. Oftentimes I'll go back to the legislative history of that one word in the statute, and sometimes you will find when you go back to the legislative history that that one word was debated in committee for 4 hours. And then you really find out what the intent of the legislature was. So if you cannot find out what the intent of the legislature was, I think you need to give it its common sense eye, if you will. But I do believe you need to try to find out what the legislative history is first, to find out what the legislature, what was going through their minds when they added that one word that has now become the source of contention and the source of debate.
Mike? Mm-hmm.
Hi, good morning. Doug, yeah, I've known you for almost 18, 20 years. So we've been friends for that. But I have a couple of questions. We do events, about 3-4 events a year, and we don't expect you to come to all our events, but at least once in a year or once every 2 years here, Judges Night Out. And Diane, I've not seen you all these years, since you got elected, we helped you, endorse you last time. But this election year, you got an opponent, that's the reason you're showing up. I think that, the Asian Committee is very large here, and the RG said twice this year that a lot of votes, race is going to be decided by the Asian Committee. I don't know if you read that. And all we ask you, once a year, at least twice a year, whenever you get a chance, come to here. I know you have family, like Doug, you have 3 kids, we talked about it, we had lunch. But once a year, I think, you can come out, and meet the Asian Committee is almost 300,000 right now. And also we got a big event coming, awards night, we honor some of the top people, like to come there, be participate, get an ad, and just mix with the Asian Committee, all the leaders of the Asian Community. That's what we ask you guys to do, come support us, when media does, because we always been with you for Doug, forever I've been with you.
And I try to come to the meetings. Sometimes I get called away. I've had a child that has been heavily medicated since he was in the 5 years old. So I don't know. And he's 17. And sometimes I have to get called away by my family to help monitor problems with that medication once it tilts the wrong way. And so I do. I come to the meetings. I don't stay often because I get called away. But I try to, I've been to a lot of your meetings, I try to come, I know the importance of the Asian community. In fact, my last law clerk was the first time I've ever had an Asian apply, and he was Korean, and I hired him as my law clerk. So I understand the importance of this. And we've had that discussion before. And sometimes the only time judges come out is when they want support and money. And I try to be there for you.
Yeah, because I don't know if you know, like John can tell you that the last 2 endorsements we had, last year we had 80%, and the year before, we generally have a 90% endorsement success. I don't think any group in town can say that success with 80-90% of endorsement. So we know what we are doing right. That's the reason we get the endorsements. That's what it is.
Absolutely.
You know, because I know Dan, I didn't see her for all these years since we helped together, and all of a sudden, because we see you there. So we just want to be sure that we want to build a relationship. Like we had a relationship for the last 15 years. You just want to help you all the time till you retire. Like we did with a lot of previous judges. We have done that.
Well, and Mike, I think you and I have had this conversation as well. I mean, I know sometimes, like I remember last couple of years, I would get a text from you, and I would text you back, because I think, as people know, I am out of town a lot on the weekends. I try not to stay in Las Vegas, especially during football season. But I think one of the issues I was having was a communication the only time I would see events was when you would text me. So somehow this year, probably by signing up at all these events, although I think it's my election email address, but I suspect I'll keep that email address. But now I'm on an email. I get the AAG luncheon invites. I get a lot of invites, in addition to some texts from you, Mike. So I think, oh, sorry.
No,
So I think to the extent, and I don't know, to the extent we know about the events, and I agree with Doug. I mean, sometimes you just can't come. I mean, I know on the anniversary event, I just texted you last week saying I'm going to be out of town September 13th. I think it's the 13th or the 14th. And I just got back last night from the Bahamas for my summer vacation with my kids. But I am now on the email invite, if you will, because now I get from the AAG actually all the invites. So if you're not hearing from us, please just call us and say, I haven't heard from you in 2 years. And then I'll say, well, and if there's anywhere I can go to get put on the email address or what have you, I'm more than welcome to do that. I'm certainly like Doug, I can't commit to going to every event because we can't do that with any group. I'm raising children that are 14 and 16, so I have to keep my eye on those 2 balls, if you will, as they're going into high school. But I love being out in the community for all different types of groups, not just AAG.
Yeah, but we don't ask you to come every year, every event. In 4 years or 6 years, if you don't show up, and all of a sudden, I have our judges. They only show up every election time, 4 years. And all the 4 years they skip AAG. They don't even think about it. Only when they're opponents, and they're going to think after 4 years they decide to come. And we don't take that lightly.
Yeah, I understand.
Yeah.
And the luncheons, it's just sometimes, I don't even know, we were just discussing before we started the luncheons, I don't even try to sign up anymore because
We
our
don't do
morning
luncheons.
calendar is so
We don't do
different.
That's Asian
lunches.
Chamber.
We have never
Asian
done,
Chamber, yeah,
we haven't done lunches at all.
Yeah.
And we only do dinners in the evenings.
Yeah.
And we have the judges' night out. We did every 2 years. We do that. Law enforcement every 2
And that
years.
was a great event.
Yeah, but I'm saying that year after even a lot of people didn't show up. Every 2 years you do something show. But naturally, you have a right to be upset because when you asking for our help, we're going to help you get elected. Doug knows that I've been with him for all these years.
Yeah.
So we want to be fair to us. That's all it is.
Yeah, I agree.